Welcome to Frank Bruno Law. Here I am, Frank Bruno, an elder law and probate attorney, continuing on with my 34 common estate planning traps and how to avoid them. So I'm in the section of do-it-yourself disasters. What is a do-it-yourself disaster? Well, it's broken down into a few parts. I'm going to start with number 6 out of my 34, relying on a handwritten will or a letter expressing your wishes. So, a handwritten will is also referred to as a holographic will. Now, in some states, that's valid. It could very well be a good will in many states. My state is New York, and a holographic will is reserved for members of the military, right? Otherwise, you need a will executed with all of the formalities of a will. Even if you hand wrote it, but you had the execution, the witnesses, if you had wanted to notarize, and notarization alone does not make a valid will. In New York, you need 2 witnesses. Let me see if there's anything else. An aspect of a handwritten will that could also be problematic is if a person signs it dad, grandpa, just their first name, Bob, right? That's a problem. You need first and last names, and so really avoid handwritten wills. Number 7, this is in the do-it-yourself disasters, drafting your own will. So even if you type your will, you really should get professional advice, someone that makes wills a routine part of their practice, right? I spoke to a lawyer today that had written a will in 2006. It was coming up for probate. I was able to ask him about the circumstances in that will. This individual attorney was one of the witnesses. His secretary was the second witness. She is still working for him. She's still around. The 2 of them, I'm able to interview them. It really is it's a benefit of going to a lawyer, right? The fact is that they know what they're doing, and not just any lawyer, but a lawyer that is an elder law attorney or an estate planning attorney, someone that makes wills a part of their practice. So when you draft your own will, there are some things that you may make mistakes about. So something could be, I'd like to leave my daughter my home located at, a certain address, 123 Smith Street. Now, what happens if you don't own that asset upon your death, and you now own 99 Main Street? Is your daughter left out? Was your intention only to leave the 123 Smith Street property to your daughter? Or did you want any home that you owned to go to your daughter? Well, that's a glaring mistake, and it really should have been anticipated or thought of, and a person making their own will may not think of every contingency. So another do-it-yourself disaster in the drafting your own will category is not having a successor beneficiary. So I leave everything to my 2 children, A and B. A dies. A has 2 kids. Do you want everything to go to B, or do you want A's children to inherit? Do you want A's children to take in place of A, or do you want the 2 children of A and your child B to get a third each? Either scenario is possible. What is it that you would like to have happen, right? And an estate planning attorney can make that happen. So that's enough for today. I'm approaching the 5-minute mark. I'd like to tell you, if you need any assistance, please take a look at my website, frankbrunolaw.com.